So, time has officially run out, and now the Department of Justice must respond regarding their course of action on the nationwide vacatur and blocking of the ATF's pistol brace regulation. And just recently, they made a major move. They dropped a criminal charge that was brought under the Biden-era enforcement of that brace rule. That gives us a strong indication of where they're headed with this issue. Also, if you'd like to support this channel without spending a dime, consider subscribing. It really helps push this content to a wider audience. Dropping a quick thumbs up and a positive comment below also helps tell the algorithm that you value this kind of Second Amendment coverage. Now let's get into the real meat of today's topic. As I mentioned earlier, we've got a big development in the ongoing fight against the ATF's classification of brace pistols as short-barreled rifles under the National Firearms Act. That controversial policy came out of the previous administration and was enforced through their final rule. We're currently waiting to see how the Trump administration plans to move forward, not just in the lawsuit, but whether they're going to repeal or revise the leftover brace rule altogether. Right now, multiple preliminary injunctions are in place that block enforcement of the brace rule for various gun rights organizations and their members. But with the new administration in office and a fresh executive order issued by President Trump that prioritizes the protection of Second Amendment rights, the Fifth Circuit Court of Appeals recently agreed to pause the Mock v. Garland case. That pause came at the request of the Trump administration, who told the court they needed time to determine their next steps on the issue of braced pistols. The court granted a 30-day hold, but it was scheduled to expire automatically on Monday, April 14th. And that's exactly what happened. That pause is now lifted, and the Attorney General's office and the ATF are now obligated to inform the Fifth Circuit of their intended course of action. Adding to this momentum, we also just got word last week that the Department of Justice has dropped a prosecution involving a braced pistol, specifically a CZ Scorpion that had a stabilizing brace installed. That case originally stemmed from Biden administration policy, which attempted to treat that setup as an unregistered short-barreled rifle in violation of federal law. But now that charge is off the table, and that decision is yet another clear sign that policy surrounding braces is shifting fast. At this point, the Department of Justice needs to let the Fifth Circuit know where they stand. Are they going to defend the brace rule? Or are they planning to walk it back? Let's not forget, the ATF has taken several legal hits in recent months over this exact issue. They've been on the losing end of several key rulings, including multiple injunctions blocking enforcement of the rule. Most notably, Federal District Judge O'Connor in Texas handed down a final decision in the Mock case, striking the brace rule down nationwide. In his written opinion, Judge O'Connor concluded that the ATF's final rule should be classified as legislative in nature, and that it didn't meet the logical outgrowth standard required under the Administrative Procedure Act. Because of that, the final rule was deemed unlawful and was tossed out. A major part of that legal reasoning had to do with how dramatically the final version of the rule deviated from what was originally proposed. If you recall, the Biden administration's proposed rule included what they called Worksheet 4999, a document with a point-based system that was supposed to evaluate brace pistols based on their physical features. Depending on how many points your firearm accumulated, it could be reclassified as a short-barreled rifle. But in the final version, the ATF abandoned that worksheet entirely and moved toward a much more vague, subjective standard. They effectively gave themselves free rein to call just about anything an SBR, not just pistols with braces. And that's where Judge O'Connor drew the line. He ruled that the shift in standards did not align with the proposal and failed the APA's requirements. That's why the rule was struck down on a national scale. So now, we're at a turning point. The administration must make a decision: stick to the failed brace rule or back off entirely. We'll see how it plays out in the coming weeks, but it's safe to say that the legal landscape around braced pistols is changing fast, and for once, it seems to be shifting in favor of freedom. If you found value in this update and want to support this kind of Second Amendment coverage, remember to hit that like button, drop a comment, and subscribe to the channel. That kind of engagement really makes a difference and keeps the momentum going. And as always, never forget, this country was built by scholars, and it will be preserved by armed scholars. At this point, all legal briefs in the Mock v. Garland case have been filed with the Fifth Circuit Court of Appeals, and now we're just waiting for the oral arguments to begin. However, once the Trump administration took over control of the case, they requested a 30-day pause to assess their position on the legality of braced pistols. There had been some last-minute push from the prior Biden administration to claim that the Bureau of Alcohol, Tobacco, Firearms, and Explosives could enforce the pistol brace restrictions purely under the statutory text without needing additional justification, but that position lost momentum. The Trump administration used the 30-day delay to figure out where they stand on this issue, but that clock has officially expired. With the abeyance now lifted, the Attorney General's office and the Department of Justice are required to inform the Fifth Circuit how they intend to move forward in this legal battle. One promising signal came just recently when the Department of Justice chose to dismiss charges against a defendant accused of unlawfully possessing a short-barreled rifle in the District of Columbia. The firearm in question was a CZ Scorpion outfitted with a stabilizing brace. In a court filing, the U.S. Attorney's Office for the District of Columbia formally requested that Count 1 of the superseding indictment be dismissed without prejudice, stating it was in the interest of justice. That decision came from the United States v. Taranto case and suggests that the DOJ is rethinking its stance on braced pistols. We've also seen multiple comments from the Attorney General's Chief of Staff indicating that changes are coming in several ongoing cases, not just in this one. For instance, there's movement in the Peterson suppressor challenge and other Second Amendment lawsuits. The AG's office has even begun investigating delays in issuing concealed carry permits in restrictive states like California, which is a step in the right direction. Now, none of this is a guarantee that the brace rule will be scrapped, but these are positive indicators. We also saw the creation of a Second Amendment task force under this administration, aimed specifically at developing legal strategies for cases like the brace rule challenge. It's important to point out that the expiration of the 30-day abeyance doesn't affect the existing nationwide vacatur issued by Judge O'Connor, which will remain active until the Fifth Circuit rules on the merits of the case, or until the Trump administration decides to revise or repeal the rule on their own terms. Of course, if the administration chooses to proceed and defend the brace rule, that would send a disappointing message about their Second Amendment priorities. However, the decision to drop the Taranto prosecution over a braced CZ Scorpion speaks volumes. It shows the Department of Justice may not be willing to stand behind this rule in court anymore. The Attorney General does seem to be facing challenges in getting full alignment within her own department. In the United States v. Morgan case, some Department of Justice attorneys continued to argue in favor of National Firearms Act restrictions on the grounds that machine guns are not commonly used for lawful purposes and therefore not protected under the Second Amendment. That line of argument appears to be out of step with the administration's stated position. Whether that was due to internal miscommunication or simply a rogue attorney operating without proper oversight, it created some tension. It's likely the AG is now working to bring tighter control over what lower-level government lawyers are putting forward in these critical cases to make sure their arguments match the administration's pro-Second Amendment agenda. Regardless, the abeyance is now gone, and the Department of Justice is on the clock. They must announce how they plan to address the mock case and what their long-term position will be on braced pistols. But based on their actions, especially the dropped charges in Taranto, it's becoming pretty clear where this is heading. If they are unwilling to prosecute under the brace rule, it's hard to believe they'll aggressively defend it in court. We'll continue tracking this story as it evolves and keep you updated with every major development. If you appreciate this kind of content and want to help support the channel, the best thing you can do is hit that like button, leave a comment, and subscribe. That kind of engagement tells the algorithm that this Second Amendment coverage matters, and it helps get the message out to more patriots like you. Thanks for watching, and remember, this nation was founded by armed scholars, and it'll be preserved by them too.